Hamilton argued that the Constitution protects jury trials, and as he put it, by refusing to freeze them in place. So here in number 83, Hamilton's going to address one of the biggest fears that the Anti-Federalists possess. Why doesn't the Constitution require jury trials in all federal civil cases? So critics worried that this omission meant that the new courts would abolish jury trials. And Hamilton says that the opposite is true. The Constitution protects the jury system by keeping it flexible and not rigid. So let's go ahead and set the stage here. Hamilton begins by affirming something that's pretty important, and that is trial by jury is essential to American liberty. But he does point out some problems, that states use different jury rules, that civil cases vary widely from state to state, and in the cases themselves. So no single rule could work nationwide. Then a rigid constitutional mandate would cause contradictions and confusion. So Hamilton argues that the Constitution leaves space for the system to work and to evolve. Now remember, there's no Bill of Rights in the Constitution as presented. His core argument, his core claim is that the Constitution does not weaken the civil jury. It simply doesn't lock it into a one-size-fits-all rule. So he insists that criminal jury trials are guaranteed, civil jury trials are not abolished, Congress can regulate jury trials nationally, and state jury systems remain untouched. And then, most importantly, omitting details is not the same thing as taking rights away. So Hamilton goes into why rigid jury requirements would backfire. He gives several reasons why forcing civil juries into the Constitution would cause problems. Like, states have different civil jury traditions. Like, Massachusetts didn't match New York, which didn't match Virginia, and one national rule could override them all. And civil cases are too diverse. Commercial disputes differ from equity cases, which differ from maritime cases, which differ from foreign matter cases. And then some civil matters require specialized judges. Once again, like maritime cases, they depend on a degree of technical expertise. Then you have a rigid rule becomes permanent. If the rule stops working, you can't fix it without amending the Constitution. And Hamilton thinks flexibility is safer for liberty. So, then, what the Constitution does protect then? Hamilton reminds readers that there are several rights that are protected, like habeas corpus, no ex post facto laws, no bills of attainder, trial by jury in criminal cases, no titles of nobility, no religious tests for office. So the Constitution already secures liberty through these structural and procedural safeguards. He argues that critics overlook what's included. So then, what about the role of Congress? Well, Hamilton emphasizes that Congress has the authority to establish federal rules for civil jury trials. Congress can expand jury use. Congress can create national standards. Congress can adapt procedures as society changes. And Hamilton believes elected representatives, not the rigidity of constitutional text, are the safest guarantee that jury trials will be preserved. Now, he goes on to respond to the fears of the judiciary, because the Anti-Federalists were worried that federal judges would use the Constitution to eliminate civil jury trials. And Hamilton offers a pretty firm counterargument. Judges cannot remove criminal juries. Judges are bound by the laws that Congress creates. Judges cannot rewrite the Constitution. And public expectations protect jury trials. Then Congress can step in at any time. So, in other words, flexibility empowers the people, not the judges. Now, if we look at Hamilton's logic, his chain of reasoning, his reasons why, first of all, civil jury traditions vary too much for a single national rule in the Constitution. And then a rigid requirement could produce constitutional contradictions. The Constitution protects criminal juries and other key rights. And then Congress can expand or regulate civil juries democratically. Silence in the Constitution doesn't eliminate rights. And finally, flexibility is a safeguard, not a threat. There it is in 6 easy steps this time. Now, Hamilton does write patiently in this one. It's a little more systematic in its approach because he's closing out his entire judicial series with this particular essay. And there's no loophole here. It's actually a constitutional design choice because Hamilton believes that structural protections matter most and democratic oversight ensures adaptation, and that rights should not be frozen by, you know, imperfect 18th century definitions from that time, right? And that although the Bill of Rights would later add more protection, Hamilton's warnings helped shape the Ninth Amendment, which says unlisted rights still exist. So, our takeaways today: the Constitution protects jury trials without freezing civil jury rules permanently. 2, Congress, not judges, determine federal jury procedures. And 3, constitutional flexibility prevents the loss of unlisted rights. Federalist number 83 is the conclusion to Hamilton's long judicial analysis here at the end of the Federalist Papers. He argues that liberty is protected not simply by listing rights, but by creating a system that can adjust, improve, and respond as law and society evolve. The Constitution's silence is not a threat. It's a space for the people to govern future questions wisely. This was Hamilton's longest essay of all the Federalist Papers, and it shows a great deal of care that he wanted to put into this question about what the Constitution states and what it doesn't state. And so hang around for the next edition here. So this is 83. We're down to 2 more to go. And I'll be taking on number 85 here, or 84 here shortly. And this is going to be Hamilton's bold argument about the Bill of Rights and whether a Bill of Rights is needed. Thanks for watching.